Okay, so today we're going to finish up some of this corporate law stuff that we've been talking about, give you some more information. Remember, we've got our final exam coming up May 10th. I know that sounds like a long way away, but visited with a couple folks in office hours today who are already getting the study guides together, and I think that's a really, really good idea. So I want to reiterate my offer to go over your study guide with you in office hours, and Dan will do the same thing and Sadie will do the same thing. Okay, so if you make the time to come to office hours, we will look it over, we'll look at your level of detail, we'll say what areas we think you have covered really well, and what areas you could use a little bit more information in. Okay, so I give this offer every semester, and maybe 3 people take advantage of it, but considering I'm the one who wrote the test, what I have to say about the coverage of it might be relevant to you. I don't know, just thinking out loud here. So it would be wonderful to see more people in office hours with their outlines. And we cover a lot of ground in the second half of the class. Now, the final is not cumulative in the traditional sense. In other words, I'm not going to go back and write new questions on first half material. You will be expected to know kind of the basics from the first half, though, like look at a hypothetical situation, and is it a civil or a criminal suit, right? You know, what state versus federal jurisdiction look like? So some of those basic things. My rule of thumb is to spend no more than 10% of your time on first half stuff, however, okay? So I think you should really spend the great majority of your time looking at that second half stuff. And remember, it starts with administrative law, okay? Which we actually covered before the midterm as kind of a scheduling quirk, but you remember there were no questions on the midterm about that. So that will come up in the second half. So important stuff. Format's going to be exactly the same, 100 questions, multiple choice, true, false. So it's going to look just like it, going to have the same amount of time. Everything's going to be pretty similar. All right, questions will be different, obviously. Okay, so let's talk about some of this corporate law stuff. I think I mentioned to you guys when I was in law school, it was my goal to get into corporate law and to do some of this stuff. And when I was in undergrad, maybe a senior or so, we used to have a class here in franchise law. And it was really interesting to me because I owned a franchise at the time. I was running a painting business that was a franchise of College Pro Painters USA, which was part of a larger company based out of Canada. And I don't know, the professor I had for that class was a lawyer here in the community, and actually later on, after I got out of law school and I went to work for another firm and I wanted to move back to Iowa City, I looked him up and I said, hey, I took your class, I got an A in it, would you maybe have a job for me? Turns out he did. So that's how I was able to parlay my tippy education into a pretty good job, and I worked at that firm for several years until I came back and started here. But I learned a lot about franchise law in that class, and then when I went to work for that attorney later, I got to work with him on some franchise cases and on some different things in this area, and it was really, really interesting to me. Now, the word franchise, you might be more familiar with this term in a sports setting, okay? When I just now Googled franchise and franchise law to see if there are any interesting news stories, I mostly got stuff about football teams, okay, and other sports teams. So that's kind of where we hear that word associated a lot. But in terms of your contact with these kind of businesses, you probably have contact with a franchise business every day, okay? If you drove by a McDonald's or a Subway or Jimmy John's or any of these other companies, quick service food is one of the areas where A large part of the market is dominated by franchise companies. You might have had your taxes done at an H&R Block at some point, or your folks may have had their house painted by College Pro painters, something like that. So these companies are all over the U.S. It's a very popular form of business. Car sales. If you go around town, you notice there's like one Ford dealer, one Chevy dealer, one Toyota dealer, okay? You don't see 3 or 4 in a town of our size, at least. Why is that? Well, it's because the parent company has granted a franchise to whoever bought the rights to have that dealership. So one of the things that you think about is geographic area with these kind of companies and how they're spaced out. So that's kind of a distributorship model. Chain businesses, fast food is one example. Gas stations, convenience stores can be another. And sometimes you see it in the setting of manufacturing or processing plant. Like if you think way back to the Escola case, I mentioned to you that Coca-Cola pretty much makes the syrup and then they ship that out to other independent businesses who mix it with the fizzy water and put it in the bottles. All right, that's kind of a franchising system as well. So what is a franchise? Is it a separate kind of legal entity like a corporation or an LLC? Well, no, not exactly. Okay, so we talk about those as an entity. Okay, you file something with the state of Iowa to create a corporation or you create an LLC. Franchise agreements are contracts. So something a little bit different than an entity created by state law. Now you might create an entity to hold your interest in the franchise, like suppose you wanted to buy a McDonald's restaurant, a franchise from them. I don't know what the rules are now, but it used to be you had to buy at least 2. Okay? So the entrepreneur who did that would usually create a corporation or an LLC to hold those restaurants. Okay? So they're 2 separate things. Franchise is actually a contract, but it makes sense to deal with it in this chapter, I think. So at like its most basic level, a franchise is a contract between the local operator and the parent company, okay? And like any contract, you've got some benefits going both ways, all right? You're going to pay something to get the right to have that franchise. And the franchisor is going to give you some stuff, like the right to use their logos, their trade dress, their ingredients, things like that. And so there's kind of a back and forth. Now, I mentioned sports, okay? Whatever your favorite sport is, there are different teams, and those are often referred to as franchises. So there's some kind of central kind of parent company, like we'll take, for instance, the NFL, the National Football League, right? If you want to start an NFL team, you have to negotiate the right to do that with them. You can't just go start a team in Iowa City and expect the other teams to come play your team, right? You have to have the right to purchase that. You have to negotiate that. And the NFL keeps control over how many teams there are, what cities they're located in, what's the salary cap for the players, what can you have on your uniform, what can't you have on your uniform, all these different things, right? So just kind of think of those different relationships in terms of this larger idea of a franchise. When you're talking about franchises, you have state law and federal laws that apply to these things. Okay? Now, contrast this with what I was telling you about your business entities, like a corporation. Okay? If you want to start a corporation, that's a state level thing. You file something with, for instance, the state of Iowa saying, I want to have a corporation. This is going to be the name. This is going to be the address. Okay? With franchises, there are some consumer protection issues as well that caused the federal government to get involved. All right. When I was looking up news for franchises, I would say of the articles that were not about sports, but were actually about like a more common kind of franchise, almost all of those were about hot new franchise opportunities. And maybe you guys have been to job fairs or career fairs, and along with companies that are offering like a traditional employment relationship, you might run into companies who are offering to sell you a franchise opportunity, like College Pro Painters or something like that. Okay, so the main thing that seemed to be in the news today was a franchise that sells a pizza that is baked in 3 minutes. Sounds kind of cool, right? Is it going to be a hit? You don't know, okay? So there are all kind of different franchise opportunities that you could look into and possibly purchase if you have, the right amount of money and things. Unfortunately, there are some parent companies who are selling franchises that are kind of a scam. Okay, this is nothing new. But one of the things I do, I represent some investors, and if they're interested in getting a franchise business, I look over what's called the offering circular, which is the document that explains the contractual relationship. And sometimes you find things in there that are big red flags. Like, for instance, one of my investors is looking at, I'll just call it a franchise business. I don't want to name names because there are a couple of them in Iowa City. But it turns out that they're disclosed in this offering circular was a lot of litigation by state attorneys general against this franchise because it was alleged to take advantage of poor people. That's kind of a red flag, right? If the state consumer protection authorities are suing the parent company saying this is kind of crooked, okay? So probably, if you want to go start a corporation, start your own business, whether it's a lemonade stand or a hot dog stand or whatever, consumer protection issues don't really come into it until you're maybe selling your product to customers. But with franchises, there are rules right up front about how that parent company has to communicate with you and what they can and cannot say, because this is kind of a hybrid of an investment and a business opportunity. It's not a job. Like, if you get offered a job from a company, you're guaranteed at least minimum wage. You can't typically lose money working, right? Worst thing that can happen is you get fired. With a franchise, you might buy in and lose a bunch of money, and people do. And so the state and federal government sometimes get involved and say, well, you've got to make all these certain disclosures. So this offering circular or disclosure statement, they can be about yay thick, like textbook thick. One of my clients, my investing clients, called me on a Friday night, of course. He said, hey, I'm looking at a new investment. Can you look over a few documents for me? It shouldn't take you too long. I said, absolutely, yeah, send it over. 441 pages. Yeah, you guys think you have it rough. Now, I get paid a lot of money per hour to read that, and I read it with a beer in my hand, but just one, not too many. But yeah, that was not an easy read, okay? But we found some things in there that convinced us we needed to negotiate a little bit if we were going to go in this business. So that franchise agreement is essentially, it's some required disclosures, and then it's a big, thick contract that you can get into with the franchisor if you both agree to it. All right? And I can't remember the exact dates on this, but it used to be, when I owned a franchise, the franchisor had to give me this, and I had to have 30 days to look it over, and I was actually not allowed to sign it and accept the offer until those 30 days had gone by. It's like a cooling off period, so you can't go to a job fair or a career fair and have a franchisor get you all excited and sign you up right then and there, and then later on you find out it's a scam and you're screwed and you're stuck in this contract. Okay, so there's kind of like a cooling off period. And I think that's probably a good law. So what all is in there? Okay, well, there's a ton of stuff that a franchisor is going to go over with you before they're going to let you use their brand and, before they're going to be willing to take your money. Okay? So these are interesting kind of regional variations on McDonald's. The Greek Mac, Big McFeast, I think that was in England, the Chicken Maharaja Mac. Those are kind of exceptions often to the rule, because when you get a McDonald's franchise, what are you selling? It's the burgers and it's the fries, and you're using their ingredients and kind of these uniform things, okay? And if you're in the food industry, that franchise agreement is probably going to specify in there directly where you can buy your ingredients, what recipes you can use, and you don't get to change that. All right? So I remember one of the guest speakers in my franchise law class was running a pizza restaurant. I don't think it's around here anymore, but it was a franchise. And in her agreement, it had some very specific things that you had to buy, like the lettuce and the tomatoes and the cheese and the tomato sauce from the parent company. And she found out she could get stuff of an equal quality at about half the price elsewhere. And the franchisor said, no, you have to buy from us. That was part of their profit scheme. Okay, so you have to be aware of those things. There's going to be some kind of payment associated with getting a franchise. So sometimes it's an upfront payment. McDonald's, it used to be $500,000. Now that was like 20 years ago. I don't know what it is now. I'm sure it's a lot more probably. Okay, or maybe there's a royalty payment. So when I painted houses, we had to kick up like 10% to the parent company of all of our revenue. Sometimes it's some sort of mix, but it's important to know. They're going to have a lot to say about where you locate. So part of your negotiation is what's the territory. Okay, if I'm selling Fords, do I have the whole city of Iowa City? Do I have Coralville as well, North Liberty? Or can you sell a competing Ford dealership to somebody who can set up right across the street from me? Because that matters. Some of the litigation I did was on behalf of another restaurant where the franchisor was trying to put competing franchises very close to them. You're probably getting the sense through all this that the parent company and the local affiliate don't always get along. That's unfortunately a big part of it, particularly as franchisees get more and more power, and sometimes they even band together into organized groups. All right, so there's a lot of money to be made in franchise law in helping resolve these disputes. They might also have requirements about the area you're going into. Like, what's the average income? How much foot traffic is there? That sort of thing really can matter for a restaurant. They might have requirements about how much cash you have on hand, that you're free of liens or lawsuits. They're certainly going to have quality control stuff, okay? So if you're going to use the McDonald's brand, McDonald's wants to make sure you're selling their high quality of food. I'm a little tongue-in-cheek here, but yeah, they don't want you going out on your own. If you're going to sell burgers, it has to be their kind, all right? The people that you employ have to be dressed in a certain uniform, things like that. And then it might have some kind of dispute resolution and remedies, because after all, it's a contract, and sometimes things can go a little bit astray. Okay, so that's franchises, just kind of a quick overview. If you ever have more interest about that, I'm happy to speak more with you. Now let's talk a little bit about corporate and organizational governance. So you're normally going to hear this as just corporate governance, but I'm going to talk about nonprofits too, because that is an important part of the law. and it's something that you might work with one day. All right? So in general, I'm going to talk about corporations through most of this, but this stuff is going to apply to LLCs. It could apply to a partnership or whatever as well. I'm just going to use the term corporation essentially though. All right, so large companies are more than their owners. Think about a company like, I don't know, Facebook. Okay, we see Mark Zuckerberg. He's up there in front of Congress or the microphones or whatever. But there's a lot more to the company than him. He's the CEO, but there's a vice president of legal. I know because I've had to hear that poor guy testify in front of Congress as well. They've got a CFO, they've got a COO, they've got, all these different people. They've got the vice president of selling your data to the Russians, all these different officers, okay? And so I just want to give you a little legal perspective on how those folks work together and what they do, all right? In the U.S., we normally have kind of a three-part structure for our companies. This isn't the way all over the world, okay? Different countries have different governance structures, but for U.S. and typically countries that follow a US/English kind of legal system, it's going to look a lot like this. So the shareholders are the people who've made the investments. They bought shares of stock in the company with their money. And I position them at the top here. Now, the reason I do that is because they select that next level, who selects the next level, and so on and so forth. All right? The shareholders get to vote on who the board of directors for a company is. If you've ever owned any shares of individual stock, like I know when I was a teenager, my grandma bought me some shares of stock in the company where she worked, okay? And so I would get these notices every now and then. We're going to have our, kind of our annual meeting. The president's going to read the annual report, and then we're going to elect directors. And if you can't make it up to Appleton, Wisconsin, then you can write your choice on this and send it in. And, I owned like 1/1,000,000th of the company or something, so I didn't have enough shares to really vote for anything, but I generally knew there was something going on there, all right? So these shareholders vote for these directors, and the directors are going to be the strategic folks. And we'll talk a little bit more about what they do here, but I'll show you just kind of a couple different structures. All right, there's one, here's another one here. I've kind of simplified it here, all right? But the board of directors are going to be people, some of them are what we call inside directors, so they work for the company as well, they have a job there. And some might be outside directors. They work elsewhere or they're retired. And they're brought in to the board of directors for their expertise in business. Okay? Typical number of board of directors, 5 or more, I think would be sort of a minimum. You always want an odd number because if you have a vote, you don't want to split vote. For large companies, maybe they might have 50. Okay, but like Iowa companies, 5 to 9 directors is usually about what you'd have. And they do the long-term strategic stuff. They don't normally do the day-to-day business of the company, so they choose who to hire. They choose who the CEO is going to be, and maybe some of the top-level executives. So in this graphic here, it's got them picking out the C-level suite, the top executives. And those execs are going to hire the employees, who are kind of crassly represented by these little time clocks down here. All right? The hourly workers. This is just a more detailed kind of org chart where you can kind of see it split off into different divisions and things like that. But the basic idea is you've got the directors And then under them are the executives. And the shareholders are kind of over everybody. Here they're represented by little dollar signs. Now the shareholders normally aren't going to do anything on a day-to-day basis with the company. I mean, if you own a couple shares of Coca-Cola stock, do you get a direct line into the CEO to tell him, hey, I really think you ought to do this different, or maybe you should change the flavoring, or, I'm worried about this trend I heard about in my business class. No, they don't listen to little investors, right? But you group enough people together, and you might be able to elect people to a seat on the board. And then you can have some voice in the policies, okay? If you're looking at a nonprofit, actually the structure is very, very similar, but you're missing one level, okay? Nonprofits don't have shareholders as such, okay? They don't have stockholders. You can't go buy shares of stock in the Red Cross or United Way or something like that, okay? With nonprofits, the legal idea is that what you're doing is good for the public, and so all the assets and things are held in the public trust. So I guess if you wanted to think about it a different way, you could say that we're all shareholders in every nonprofit, okay? But you don't have specific people who have a claim on the assets of the company like a shareholder in a for-profit, okay? Now, the people who organize the nonprofit are going to choose the directors. And then perhaps as it grows, you may have a membership structure. And they may have a vote for directors. So they might act in that way like shareholders. But they don't have a claim on the assets. Typically, the top executive in a nonprofit is called an executive director. Sometimes it's a CEO. What they call the person doesn't really matter. And then under them, staff members, paid staff members, and possibly volunteers. So it's a little bit of a simplified structure, but it's basically the same. Remember, one of the cool things about corporations and some of the newer and better forms of entity is that all you can stand to lose is the money that you put in for your investment. Okay, so if you bought some shares of Facebook stock, maybe your shares have probably been going up to this point. Now maybe they're going to go down a little bit, but in no case are you going to lose any more than the money you put in. That's all you can lose. Okay, so if there's some kind of huge fine levied against Facebook or they get sued, nobody's coming to you with their hand out saying, you own 0.5% of the company, so that works out to $44,000, please, right? So this is kind of a good thing. This is that whole limited liability concept. Now, what about these directors and officers? So I told you the directors might work for the company or they might be outside directors. If they're going to be a director for a large company or maybe like a bank or something like that, they're often paid for their time. Can range from a small amount to a large amount. All right. And executives, these are your top managers. They're definitely paid for their time, usually very well. They work every day for the company, okay? Under the law, we say these folks have a fiduciary duty to that company or that corporation. And we kind of introduced this term the other day. It's a trust relationship. And it makes sense, okay? The directors, we expect them to set the strategic direction for the whole company. We ought to hold them to some kind of standard. Same thing with the executives. They're making the big decisions. So we hold them to a standard, okay? And the duties that we're going to talk about primarily are the duty of care and the duty of loyalty, okay? Some great WikiHow clip arts on how to uphold a fiduciary duty. I guess one part involves shaking hands, and the other involves kind of petting a contract, sort of what it looks like in that picture. I don't think that's actually it. I think that fella is showing off some kind of document that memorializes his fiduciary duty, okay? The duty of care is one of these basic duties that we talk about, and it's really simple. Like, there's a bunch of fancy language around this, but it's like, are you acting in the best interest of the company over your own? And are you acting kind of in the same way that like a reasonable person would take care of their own needs? All right? That doesn't sound like a really high bar, right? And it's not. You have to be either really stupid or really crooked to fall short of this. And yet people do it every day, of course. But the gist of it is, if you're making a decision on behalf of the corporation or the nonprofit, because these apply over in the nonprofit realm as well, the decision has to have some kind of rational business purpose. Note that I don't say it has to be a good decision, because you can't always judge what's going to be a good or profitable decision at the time. You make your decision with often incomplete information, do the best you can. But does it have some kind of rational business purpose? Is it legal? And did you do a little bit of research? You know, is it an informed decision? This is a very, very low bar, okay? Very low bar. Yet we see people violate it all the time. So what happens when shareholders think that the managers have managed to trip over this very low bar? That's where we get into lawsuits. So we mentioned the other day, like, shareholder derivative suits, okay? So you own some shares of a company, and you think they're behaving so stupidly that they violated these duties, okay? So maybe you bring an action to ask the court to interfere, saying, look, the managers are so dumb or so crooked that they can't manage to do this. So I suppose we have a few Cubs fans in the audience, right? There are night games played at Wrigley Field, but did you guys know that there were not always? A little bit before my time, too. But going back all the way to 1968, this was controversial, okay? So the Cubs are owned primarily at that time by the Wrigley family. They were the majority owners. And then there were other owners as well. And some of them grouped together, and they were going to management and the majority shareholders and saying, we think you ought to play baseball games at night. We think you're leaving a lot of money on the table by not playing night games. And the majority shareholders said, no, we have good reasons for not doing this. There were some concerns about the neighborhood, the traffic patterns, how it was going to affect adjoining landowners. You know, they had some different reasons. And so the group of folks who thought that they should play night games said, those are stupid reasons. We're going to have a derivative lawsuit, and the court is going to force you to do this. Okay? Now, there are some other complicating factors during this time. Profits were way down, okay? Perhaps it had to do with they had the fifth worst record in the league. Chicago White Sox at the time had the fifth best, so there was some rivalry issues there. Maybe people were going to see the White Sox instead. But this got up to the court, and they looked at it, and they applied what's called the business judgment rule. And this case was not the first use of the business judgment rule by any means, but we thought it would be kind of an interesting one for you guys based on how many people are baseball fans or Cubs fans. And the court essentially said, we're not going to get involved, okay? Minority group of shareholders, we understand your concerns. Majority group of shareholders, we understand that you have some reasons for not doing this. We're not going to get in the business of running your business, okay? So I'm guessing the minority shareholders had some profit projections that they brought in as evidence and said, you know, you could probably be making this much, you know? And the court says, we're not going to get into the business of running companies here. And they said that we're only going to get into a corporation's internal affairs if there is a breach of good faith, that duty of care, or some kind of fraud. So the business judgment rule, as it's been stated in many cases, says the manager's got a duty of loyalty and a duty of care. And if you go about trying to make your managerial decisions in accordance with that, then the court's not going to overturn your decisions, okay? That's really important. Imagine if you were, say, the general manager of the Green Bay Packers, okay? If you're a Packers fan, and I am, last year our star quarterback got hurt very early, and the team decided to go with a backup quarterback who looked like he'd be pretty awesome in the preseason. Turns out during the regular season he was a little bit shaky. Good guy, wasn't quite ready. Okay? A lot of Packers fans said, hey, you really ought to go out and get a veteran quarterback. There are several on the market until Aaron Rodgers gets healthy. They didn't. Packers had a pretty crappy season, missed the playoffs. Should I get to sue the Packers, the general manager, and say, you screwed up. And because you screwed this up, we lost such and such games, and revenues went down, and people aren't buying Aaron Rodgers jerseys, and yada, 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 right? No, business judgment rule. They did the best they could. If the manager acts without a conflict of interest, with the care of an ordinary person, and in their best estimation, the best interest of the company, that's good enough. Because it would be a nightmare to be a manager, a director, or an executive if your every business decision could be challenged in court, right? Who would do it? Nobody. We'd all go be lawyers, right? You'd have a real need for legal services. So what's the duty of loyalty? Essentially, it's just, in a reasonable manner, putting the company's needs over your own. So, I'm not an executive at the University of Iowa, but just suspend disbelief for a minute and say, it's pretty nice out today. I've really been wanting to go trout fishing, but I have this class and I have another class after this. Should I just cancel classes and go fishing, right? That's probably not in the university's best interest, is it? It's in my best interest, maybe, but not in the university's. Okay? That's kind of the duty of loyalty in a nutshell. Okay? You don't have to kill yourself for the company. If I were sick or something, and I had the flu, and I thought I couldn't make it in, I probably could call off then. But, in general, put the company ahead of your own selfish desires. Okay? If you do something that's self-dealing, that's going to violate this duty. So suppose I was here teaching you this class, and then I was also video recording it and selling it to some other university. That would be self-dealing, right? I shouldn't do that. Or if you take away an opportunity from the company that you work for, or where you're a director, and get it for yourself, right? Kind of famous case on this is a horse racing case. There were 3 guys who made a company to buy racehorses. And one of the guys heard about this awesome racing prospect, and instead of telling his partners, he went off, formed his own company, bought that horse on his own, raced it, and won a bunch of money. And his old partner sued him. The court said, yeah, you were in the business of buying horses. You shouldn't have taken that opportunity away. Maybe some of you guys know these guys. Season 12, now on Netflix. I'm working my way through it. These are the Trailer Park Boys. And they're a godsend for a law teacher because they are constantly starting businesses and screwing it up. And so they engage in both criminal and civil misbehavior on a large and frequent scale. But in a recent season, Bubbles, who's kind of the least criminal of the group in the show, decided he was going to get out of the criminal lifestyle, and he was going to start a shed and breakfast. It's like a bed and breakfast, except you sleep in a shed. And his particular wrinkle on the concept was that you could bring your cat with you, because if you've seen the show, he's a big fan of kitties. Okay, so he started the Shed and Breakfast for kitties and the people who love them. And of course, his friends, Ricky and Julian, wanted to get in on the business with him, and he's too nice to say no. So they formed a company, all three of them, to promote this and to build out several sheds and have people come in, and money was supposed to come in. Now, at some point, Bubbles had to go away to do something. I don't remember what it was, but he was away for a few days. Ricky, who's maybe the most criminal of the group, decided while he was gone that he was going to turn a couple of the sheds into a marijuana growing and refining operation, which was illegal. And then he and the third partner, Julian, sold the marijuana products and kept the money for themselves. Bubbles came back. Not only were the Shed and Breakfast not all fixed up and ready to go, but they were making hash oil out of there. Okay? Hence, Ricky and Julian violated the duty of loyalty to Bubbles in a very dramatic fashion. It's not usually that overt, but if you ever need an example of this or want to see how not to run a business, it's a terrific show. Now, what about self-dealing? Okay, so I gave you a little bit of an example before, but often you think about a situation where people own multiple businesses and you might do something that benefits another one of your holdings. Okay? I'm not going to pull any examples from our government, but you could read the news and maybe find some. Okay? One example I ran into with a nonprofit was that I was on a local nonprofit, and we were going to have a 10K walk and run road race kind of thing, all right? And we wanted to have T-shirts printed up. Well, it just so happened one of our directors ran a print shop, okay? Now, we had to buy the shirts from somewhere. Should we buy it from the director, help their business out, or is that illegal? It's conflict of interest. It's not per se illegal. It's not per se a violation of the duty. When you have these kind of things, what we ended up doing was saying, well, okay, your shop can put in a bid, and we'll get, a couple other bids from other shops. You don't get to vote in this transaction. You'll be recused from this. And if we can get it at a competitive price, then, we'll go with you. If other places have a better bid, then we'll go with them, all right? But they didn't get to vote on that transaction because that would have personally enriched them. So if you look down here, there's a couple kind of qualifications in that situation. Can you have approval by the disinterested members of the board or the shareholders, and was the transaction fair? So it's not a situation where it's necessarily illegal or prohibited, but you don't want that person voting on it or approving it, okay? And unfortunately, there are a lot of managers who don't get the memo on this, and you see people in these situations. Now, one final thing about corporations, and this is going to apply to LLCs as well. One of the main reasons you set up these structures is to protect your personal assets from things that happen in the business, okay? That usually works out okay. But there are people who would abuse this, all right? So I think I've told you a little bit about a fraud case where I represented the plaintiff. It was a civil case, not a criminal case. And the defendant was a developer, if you will. And he had defrauded my client. Essentially, he'd signed a contract to build out a subdivision, and he got certain payments from the client, and he just decided one day that it would be more fun to leave the state and be a bartender somewhere else and take the $500,000 with him that belonged to my client. Didn't find him for a few years. Moved back. By then, with the interest, there had been a judgment entered against him for a couple $1 million. He decided, I'm not going to pay that. But he didn't like being broke either. So he started another construction company in his wife's name. Can you do that? Start an LLC in your wife's name? That's not per se illegal. The ethics of it are debatable. But his position, so we went and attempted to garnish the income from that company. And his contention was, no, because I'm not getting any money from that, and your judgment is against me, not her. He said, I'm a volunteer, okay? All this money comes into this construction company. That's my wife's money. It's not mine. I'm a volunteer. I said, well, that's an interesting legal theory. You know, we're going to garnish it anyways. So then he sets up an LLC in the name of each of his kids. We're talking 14 years old, 16 years old, okay? All of a sudden, they're CEOs of construction companies, and all this money is rolling in, right? And he's just kind of giving our client the finger, saying, nope, that's my kid's company, not mine. You can't get it. So we kind of sued his whole fraudulent freaking family and got them into court in front of the judge, who was a former prosecutor. And we went in on a theory of this veil piercing. So the idea of the corporate veil, and I don't know why they call it veil and not armor or something like that, but the idea of the corporate veil is there's a line between your personal assets and the company assets, and there's a line that the liabilities can't cross into, okay? But if you abuse it, if you do fraudulent things, if you're trying to avoid paying legitimate debts, if you're commingling assets of your personal and business things in a fraudulent way, like one of the things this guy would do, he liked to drink, so he would take the company credit card and buy like $200 worth of that sweet, syrupy Amana wine and drink it, you know, which I'm surprised it didn't kill him. But, you know, he's like, no, that's a business expense, you know. Well, the court looked at that and said, you're kind of using this corporation as your piggy bank. So eventually what we got was a court order that said, any business you or your family start is going to be considered one and the same as you. They kind of just rolled all these fraudulent folks up into a ball and said, anything you do is subject to this judgment, okay? So that's called piercing the corporate veil. It doesn't usually happen by accident. It took us years of litigation to get to that point. And as far as I know, I ended up leaving the firm, but I don't think they ever collected the whole amount. So it's not great, but there are remedies for people who try to abuse this stuff. Okay, and that's corporations. We'll see you guys next week. We'll do some more exciting things.